I'm with Berkeley Law and Technology Group, one of the partners of our firm. We're an IP boutique, and today we're going to be talking about picking a brand name. And this could be a brand for your company in terms of a product, a service, or it could even be your company name that you want to use as a trademark. Often this is one of the first steps you do after coming up with a new product or service or forming your business. So some of the considerations are, how do I know if my brand is available? It's one of the questions a lot of people ask me when they call as a potential new client. Or how do I ensure I am not infringing on another party's brand? And that's a great question and super important. What are the key considerations? So when it comes to branding your product, probably the most important thing to consider is your brand should be distinctive, especially if it's something that you want to protect. Now, you can protect a non-distinctive brand through use over a period of time, but when you're first starting out, there's always a challenge between being descriptive and being distinctive. Descriptive helps the market understand what your product or service provides, but it doesn't provide any distinctiveness. A distinctive mark, on the other hand, is unique and proprietary to you, so to speak, and it will take some time to educate the market on what that brand actually means. But that's an important distinction. Find a distinctive mark, and then determine how you plan to use your brand. The scope of the goods and services, for instance, is it going to be a logo, or is it going to be a word only, or a combination, or a tagline? How do you plan to use that? Are you going to use the tagline with the logo and the words? If it doesn't have a tagline, is it going to be a logo plus words, always used together or used separately? If it's used separately, you might want to consider a separate application for your word only portion and the logo portion, and maybe a separate application for the combination of the two. The next thing we would look at is you should perform a trademark search. One of the ways that you understand whether or not your brand is available, or the brand that you came up with is available, and that you're not infringing on someone else's mark, would be to perform a search. Now, we're going to do a separate video talking about trademark searches, or you can just give us a call and we can assist you with the search. Either way. You can protect your mark as a 1B filing or a 1A. And what that means at the U.S. Patent and Trademark Office is 1B means I have an intent to use the mark in commerce, so I want to file it as a placeholder. 1A means I'm using the mark in commerce already and I want to file to protect that. So there's a consideration there. You don't have to wait until you're using it to go ahead and protect your brand. So we perform a search, everything looks good, then we would proceed to file a trademark application. Now, that filing a trademark application process is fairly straightforward, but there are a number of things to consider. And if you haven't done it before, sometimes it's easier just to get an attorney to help you out. The people that do it all the time, they're going to help you avoid some of the pitfalls that occur. So whether you're currently using the mark, one of the questions would be, are you using it or not? So that helps you with your filing basis. Another question would be, do you want to claim color, font, style? A lot that we could say about that, but I don't have time in this video. How you describe your mark. So if it's a logo, then you're going to have to describe your mark, and it's important. Otherwise, the office act you'll likely receive an office action from the Patent and Trademark Office if you don't describe it properly. And then the scope of goods and services with which you're going to use your mark.